As they say in the Lords, we'll call the meeting to order, so welcome. We're used to that. Where people speak at the back, that's allowed on the whole, but slightly soft voice. And really welcome to this discussion, which focuses around the legal status of the PKK as a terrorist organisation and how that can be dealt with. Melanie is going to host. But just to say before the meeting began that for me, essentially, the future of humanity is in many ways being decided by the Kurds. I've watched with huge inspiration and interest the transformation of what was essentially a Marxist-Leninist national liberation movement into a democratic and federalist structure, the central role of women in the political organisation, and recently the extraordinary story of the defeat of ISIS in Syria, and the development of a genuine democratic agenda in Turkey. So tonight we're going to be focusing overwhelmingly on the legal aspect, but for me it's also a political struggle that is going on, and that I'm completely committed to gain the recognition for the PKK, for the YPG, for the YPJ, as partners, democratic partners for our country in the future of that region, and I believe that they offer the greatest hope, the practical hope with the council systems and with the form of democratic and federal government. So I'm really honoured. I will always be honoured to be associated with that. And to you, Melanie, who's chair.
Thank you very much, Lord Garsman, for agreeing to host this meeting tonight, which, as you said, is going to be focusing on the legal issues, particularly of a case from September 2017 in Belgium, when 42 people were alleged to be members of the PKK and leaders of the PKK, and Jan Fermon represented them successfully, arguing that the anti-terrorism legislation did not apply in this case, and that there was a conflict between the Kurds and the Turkish state in Turkey, and that therefore this conflict should be governed by the rules of international humanitarian law, and this was a successful defence. For those of us who have been campaigning on the Kurdish issue and seeking a political solution to this ongoing conflict, this legal decision presents an important opening for there to be a different approach to this struggle that's been going on for many decades. And the problem of the listing of the PKK as a terrorist organisation. And the consequences of this listing are that political debate around this issue is silenced and vast swathes of the Kurdish diaspora are criminalised. So this case presents, as I say, a new opening, a new chance for us to discuss the political implications of this listing and how we can seek to challenge it. And Alistair will take this discussion a bit further and discuss the political debates around the listing of this organisation in the UK and the possibility of mounting a challenge here. We also have with us Les Levido, who was one of the people who set up CAMPAC, Campaign Against the Criminalisation of Communities, to further the political discussion around this broader issue. So first, we're going to go to Jan, who was the counsel in this case in Belgium in September. Thank you.
Okay, thank you, Madam. Ladies and gentlemen, thank you for being here and giving me the opportunity to share with you some of this development in Belgium, which I think might have some consequences also beyond Belgium, and that is, of course, one of the reasons I'm here. First of all, let me give you some facts about the case that was prosecuted. the national prosecuting body, the federal prosecutor, started an investigation in 2009 into alleged members or leaders or individuals who were somehow assisting the PKK. It was an investigation based on the Belgian anti-terrorist law, and actually it was in line with what we had seen developing throughout Europe, especially since 9/11, where increasingly, in an increasing number of countries and with an increasing aggressiveness, organizations allegedly and individuals allegedly linked to PKK, and that is a very broad concept because everybody is considered to be linked somehow to PKK when one is active to defend the rights of the Kurdish people, were prosecuted, in some countries also effectively imprisoned, and the Kurdish movement allegedly linked to PKK was increasingly criminalized. For my country, that was a new development, because up until, I would say, the end of the 1990s, the traditional position of the Belgian government was, as long as you don't export your conflict to our streets, as long as you don't fight in our streets, you can speak freely. The Kurdish movement can develop activities, can organize, and will not be criminalized for organizing on the Belgian territory. At that time already there was, of course, strong Turkish pressure to change that policies and to criminalize, to prosecute, to ban, to harass administratively organizations the Turkish government considered to be linked to PKK, but the Belgian authorities and some other, and the Netherlands, France to some extent, resisted the Turkish pressure on this and had a policy of, I would say, as long as there was no violence on their territory, they did not intervene. The situation was slightly different in Germany, where the whole criminalization process started earlier, and actually I'm not aware, but I'm happy that maybe we will hear some about that. I don't know how it developed in the UK. Since the beginning of 2000s, the concept of the struggle against terrorism as it existed in Turkey previously, where anything related to the Kurdish movement is anyhow considered as terrorist, that concept, the Turkish anti-terror law, which was at that time still very much criticized by the European Parliament, instead of changing the situation in Turkey, actually that Turkish anti-terrorist law and the anti-Kurdish Turkish policies spread throughout Europe, and criminalization really became very important. It's in that general framework that the Belgian prosecution started the case in 2009. Actually, I should say a few words about how this case came to be, because it's an interesting story. We know that since 2006, the Turkish authorities were particularly strongly pressing the Belgian authorities to prosecute and to take all kinds of actions against essentially two Kurdish organizations present in Belgium. One is the Kurdish television, which has studios and production houses on the Belgian soil near Brussels. And the second one is the representation of the Kurdish National Congress, who actually does represent the Kurdish people and does lobby work both in the Belgian Parliament and in the European Parliament. And these two were the main targets of this Turkish pressure on the Belgian authorities. The Turkish pressure was then relayed by the US Embassy. The US took a very active role in pressuring the Belgian government to prosecute PKK and to act against PKK, and especially against the KNK representatives and against the Dutch. And we know it because there is a flow of cables from the US Embassy in Brussels to the CIA, to the State Department, that discuss in detail these initiatives and the pressure put on the Belgian government. March 2006, May 2006, November 2006, October 2007, etc., etc. And the titles are very interesting. Turks provide information on PKK activities in Brussels, approaching Belgium on PKK terrorism, US government delegation approaches Belgium on PKK terrorism, demarche to Belgians on combating PKK terrorism in Europe, US government delegation approaches Belgium on terrorism, subject PKK follow-up on Kartal. Ramzi Kartal is one of the KNK representatives who is living in Brussels, who is a political refugee in Brussels. Belgium freezes PKK associated Roche TV assets, PKK update. We have these cables because they're all published on WikiLeaks. And so we could exactly see how this case has been built up since 2006. We could also see that there were two approaches in the Belgian authorities. One group was systematically saying to the US Embassy, when again they pressured the Belgians to prosecute, one group systematically said, we are willing to prosecute, but what the Turkish government provides us with as elements, as evidence, is rubbish. And we can't prosecute on this. This is a propaganda brochure and not a criminal file. So if you can push the Turks to provide us with serious criminal evidence, then we will prosecute. But up until now, we don't see any. And we don't have good reasons to prosecute. From the very beginning, there was another line within the Belgian authorities that actually was very keen on prosecuting and on cooperating with Turkey in this case, especially the federal prosecutor, who is the national prosecuting body in terrorist matters, was very keen on working with the US and with Turkey to attack, to criminalize the Kurdish organizations in this. Actually, there was a turning point in October 2008. 3 Belgian ministers visited Ankara, and one of the cables says that has been a turning point. And 3 months after the 3 Belgian ministers who discussed the matter with the Turkish authorities, the Belgian chief prosecutor, Johan del Muller, made a trip to Ankara in January 2009, and CC, in March 2009, this gentleman, Belgian federal prosecutor, launched an investigation against the Kurdish organizations in Belgium. What did he do? Because we only had the rubbish from the Turkish authorities, the materials on which both the Belgian judicial and intelligence authorities and the Ministry of Foreign Affairs had repeatedly said we can't prosecute on this basis. So the federal prosecutor created his own case. How did he proceed? He toured all the regional prosecutors in Belgium and tried to find out if there was any case that might be linked to PKK. So there was a fight in a Kurdish association in Antwerp. People started fighting in a Kurdish association in Antwerp. There was criminal investigation, small criminal investigation going on in Antwerp. He picked up that. There was women's gathering in the east of the country, which is then automatically branded as a camp. But actually it's a gathering of women discussing politics and the role of women in the Kurdish movement. There was some kind of an investigation on what happened exactly in this camp. The federal prosecutor picked that up. There was somebody who was arrested at the airport with too much money on his way to the north of Iraq, under investigation for money laundering. And so the prosecutor collected all these minor files, which generally there's nothing to it, put them all in one basket, then constructed on top of that basket a case against the KNK, saying this is the network of PKK in Belgium involved in multiple criminal activity, and all that is under the control of the people that are in the Kurdish National Congress, and the mouthpiece of this terrible network engaged in fighting in Kurdish associations in the country, the mouthpiece of all this is the Kurdish television. And so he started a prosecution at that time, of course against the people who fought in the association, but also on top of that against the three main leaders of the Kurdish National Congress, Remzi Kartal, Zubair Haidar, and Adem Uzun. Adem Uzun being, by the way, one of the negotiators in the peace talks that were held in Oslo. Remzi Kartal being one of the targets of the US Embassy. They discussed with the Belgian authorities the possibility to withdraw his refugee status and to send him back to Turkey. And the Belgians said, we can't do that, it's impossible, he's a recognized refugee. But so he was now under prosecution by the federal prosecutor, and two companies that were also investigated, two production houses for the Kurdish television, Rosh TV and Sterk Productions. Some of these people, some of the two of the three KNK leaders were actually also arrested in 2010 when the case, the investigation developed. They were released after 15 days by the court because the judges already at that time looked into the file and saw nothing. No acts of violence, nothing material, only you are leading the network of all these activities in Belgium. The investigation went on until 2016, until half 2016, and then under the Belgian criminal proceedings, procedural law, a court has to decide whether this case will go to a trial court, yes or no. So it's not the prosecution who decides on this, it's a court who decides on this. And so the prosecution has to ask in some way the authorization of this court to prosecute the case in a trial court. This preliminary court will actually, two questions will be taken into consideration. One, is there sufficient evidence to conduct a trial? Not to convict, but to conduct a trial. Do we have sufficient materials to have a trial? And two, is there any legal obstacle to the prosecution? In that framework, we then raised a clause in Belgian anti-terrorist law, which says that the anti-terrorist law does not apply to armed conflicts as defined by international law. It's a clause which is not, it doesn't only exist in the Belgian law, it exists in the EU framework decision on combating terrorism, which is a kind of common standard for terrorism laws throughout Europe. But it also, the same, exactly word by word, the same clause also exists in almost all other international treaties on combating terrorism. And so the clause says that anti-terrorist laws do not apply to situations of armed conflict as defined under international law. Armed conflict as defined under international law, it's either conflicts between states, but it's also conflicts, internal conflict between a state and a non-state actor. However, there are two conditions. The conflict, the two criteria to see if it amounts to an armed conflict or if it's a matter of sporadic violence and therefore sporadic criminal violence. There are two criteria. One is the intensity of the conflict. Is this actually a war or is it some clashes? So the intensity of the conflict with a whole series of sub-criteria, which is the type of weapons which is used, how long is the conflict going on, what is the territorial spread of the conflict, which kind of weapons and which kind of forces are engaged in the conflict, etc. All these grounds. The intensity is assessed. And the second point is, what is the degree of organization of the non-state actor? Because if it's just loose groups of people doing harm, then it's not an armed conflict. But if it's an army, which means people who are organized, who are under responsible command, with a command structure, with the possibility to communicate between different areas where they conduct armed struggle, with wearing uniforms, with military training, with an organization that is capable of implementing international humanitarian law, the Geneva Conventions, the laws of war, on the ground, with also structures that allow to enforce international humanitarian law, which means to prosecute people in their own ranks who commit war crimes. Then, if you have this kind of organization, if you have at the same time a conflict with sufficient intensity waged by a non-state party that has a high degree of organization, then a different legal framework will apply. It's international humanitarian law and not national criminal law. International humanitarian law doesn't mean impunity, because if the non-state party in a conflict commits war crimes, conducts attacks against civilian targets, for example, then the authors of those war crimes and all those who contributed to those war crimes can be prosecuted for committing war crimes. So, applying the framework of international humanitarian law does not mean that there is a situation of impunity that is created. So we argued, both in the first instance court and also in the appeal court, after the prosecution and the Turkish state, who is part in the proceedings, appealed the decision of the first instance court. Also the appeal court said this is an armed conflict. It has a high degree of intensity for various reasons. It's been ongoing for a long time. Turkey uses all forces, including air force, to attack, and missiles to attack, etc. So on one hand, the intensity is sufficient to consider it as a war and not as a matter of criminal violence. And two, PKK does have the degree of organization that is necessary to consider it as a party in an armed conflict and not as a terrorist organization. And so anti-terrorist law doesn't apply to that situation. And dismissed the whole case and actually barred the prosecution on that ground. The prosecution, of course, appealed it to the Supreme Court, and it's still pending in the Supreme Court. We will probably have a hearing in the Supreme Court somewhere in January or February. But the Supreme Court can only hear the case on points of law. So the factual assessment that this is an armed conflict is not under reconsideration. Now, why is this important? And I will conclude on this because I don't want to go into technicalities on the law. I think there are mainly four reasons why this is important, why this is an important decision. The first one is that upholding this distinction between situations of armed conflicts and other situations of violence is extremely important. The International Red Cross has always taken a very firm stand on this, lobbied to get this exclusion clause on which the decision is based into international treaties, into the EU framework decision, into international legislations, for a very simple reason. Because they want to promote the respect for international humanitarian law. And they say, if you prosecute a non-state party that is involved in a war, if you prosecute it for whatever it does, there is no incentive whatsoever to protect civilians. Because if you prosecute them equally for attacking a military convoy or for attacking a civilian, a group of civilians, if you prosecute them anyhow, there is no incentive for this group not to attack the civilians. If you decriminalize the attacks on legitimate military targets, if you say, if you attack a military convoy, then that is not a crime under international law. But if you attack civilians, then you will be prosecuted for a war crime. You create a distinction which is an incentive to respect and to protect civilians in the conflict. That is the first thing. And I think the Belgian court very clearly understood this and took a decision which is right from that point of view. The second point is that this is a signal to the Turkish authorities, and I think the signal will not be heard at this time, but I hope it will be heard in the future, that they have to solve the conflict, that they have to negotiate a political solution. Because conflicts have to be solved. Terrorism has to be eradicated. If you label your opponent as a terrorist, then the only thing you can do is fight him to the last, as far as you can. Eradicate the terrorism, use all means possible and necessary to stop a terrorist. If you admit that you are in a conflict with somebody else, then you try to find a solution to solve it. So branding it as a conflict and not as a matter of terrorism, I think is an important incentive to the Turkish authorities to come back at some point to the negotiation table. And I know that we're not very close to that, but we hope at least in the future that it will develop in that way. The third point is, the third reason why it's important is that this decision, to the extent that we can build on it and have this approach spreading throughout Europe, actually creates space for the Kurdish community to express freely. Under the anti-terrorism law, propaganda for a terrorist organization can be an offense. But what is propaganda for PKK? Is it speaking positively about some of the actions of PKK? Is it informing the public, as the Kurdish television did, about the actions taken by PKK and the positions taken by PKK? They are prosecuted because they inform the public on the positions of PKK and on the actions of PKK. And so, under anti-terrorism laws, what is allowed or what is not allowed in the realm of freedom of expression of information is extremely unclear. And so that, of course, has a chilling effect on the Kurdish community, but it also has a chilling effect on those who want to discuss with the Kurdish community on how to find a solution for the conflict in Turkey. If you don't apply anti-terrorist law, but you apply normal criminal law, the lines are extremely clear. No hate speech, no incitement to violence. And that's it. If you incite to violence or to hate, you're criminally liable. If you don't do that, you're within the realm of freedom of expression. And you can discuss freely political solutions, suggestions, the different forces in the field. And so I think